This meeting is being transcribed and summarized.
Good evening. Welcome everyone to the 19th Board of Adjustment meeting. Can you please do roll call?
Yes, sir. Mr. Gallo?
Here.
Mr. Carter?
Here.
Mr. Jenkins?
Here.
Ms. Denny? Mr. Simpson?
Here.
Ms. Hudson?
Here.
Mr. Cusick?
Here.
Thank you. That's 7 present.
Thank you. 7 present. We have a quorum. Introduction of staff, please.
Good evening, everyone. My name is Jesse Lindenberg. I'll be presiding as hearing officer for tonight's meeting. To my left is Mark Kennedy, our IT specialist, and down at the end we have Mr. Fred Townsend, the legal counsel for the board.
Thank you. At this time, everyone please stand for the Pledge of Allegiance. Any additions or alterations to tonight's agenda?
No, sir.
Thank you. Public hearing introduction.
Good evening, everyone. My name is Jesse Lindenberg, and I will preside as hearing officer for tonight's public hearing. This hearing is being conducted for the purpose of providing the citizens of the county an opportunity to present testimony on these applications before the Kent County Board of Adjustment. Everyone will have an opportunity to speak. This will provide those who wish an opportunity to give their testimony. If there is a group of interested citizens in favor or opposed to any of the applications, they may wish to elect one spokesperson among them to present testimony to the board. There is an official recording of these proceedings being made. Therefore, we ask that only one person speak at a time and that they speak clearly. Furthermore, there shall be no cross-examination of witnesses permitted during the public hearing, but the board can ask the applicant questions after any opposition if necessary. As a courtesy to other participants in this hearing, a maximum of 5 minutes will be allotted to any person who wishes to provide testimony. The chairperson of the board has the discretion to allow additional time if deemed to be necessary. To make statements when your application is called, and for the record, please give your name, address, and allow our attorney to swear you in prior to providing testimony. Copies of any written statements or exhibits used during the hearing should be presented for identification so that they may be included in the permanent record. The procedure on each variance application will be as follows. The legal notice will be read on each case prior to the receipt of testimony. There will be a brief explanation of the application by the staff. The board will then receive testimony from all of those in favor of the application, followed by testimony of those who may be opposed. Once those persons in favor and those in opposition have had an opportunity to speak, the hearing on that application will be declared closed. Decisions on all applications heard this evening will be made by the board during the business meeting following the public hearing. However, you are not required to remain after the public hearing once your request has been heard and closed. During the business meeting, the board will consider all information of record. A common vote of 4 members of the board shall be required to make a decision on each application. If you do not wish to wait for the business meeting later this evening, you may call the Kent County Planning Department tomorrow between 8 a.m. and 5 p.m. at 302-744-2471 to learn of the board's ruling. All applicants will receive written notification of the board's decision. This notice may not be mailed until after the next scheduled meeting, but if approved, you are welcome to apply for any necessary permits prior to receiving this by mail. Please keep this decision in your records for both you and all future property owners. The public notice for this evening's hearing was published on Thursday, March 19th in the Delaware State News. In addition, all of the subject properties were posted with a sign prior to the hearing to further notify the public of the nature of the applications. Thank you.
Thank you. This time we'll have statement by counsel. Mr. Townsend.
Thank you, Mr. Cusick. The standards for the granting of variances are set forth by the Delaware Supreme Court in the case known as Board of Adjustment versus Quick Check Realty. The standard applied to area variances considers whether a literal interpretation of zoning regulations results in exceptional practical difficulties of ownership. And to make that determination, the board must weigh the following 4 factors. First, the nature of the zone where the property lies. Second, the character and uses of the immediate vicinity. Third, whether removal of the restriction on the applicant's property would seriously affect neighboring properties. And fourth, whether failure to remove the restrictions would create an exceptional practical difficulty for the owner in relation to the owner's efforts to make normal improvements to the property. This factor is satisfied only when the difficulties alleged by the owner are practical rather than theoretical and exceptional rather than routine. And it's here where the board determines whether the applicant is seeking more than is minimally necessary to relieve the asserted difficulty. In general, the board is not permitted to consider factors other than the 4 I've listed, so those speaking both in support of and in opposition to applications are urged to present only information bearing directly on the 4 factors, which restated briefly are 1, the zoning district, 2, the character of the immediate vicinity, 3, the effect on neighboring properties, and 4, whether the applicant faces exceptional practical difficulties of ownership. In particular, presenters are instructed to exclude from their presentations any discussion of personal disputes or acrimony between the applicant and neighboring property owners, as the board is unable and unauthorized to resolve such disputes. Presenters must limit their remarks to those issues the board can address. Mr. Cusick, that concludes my statement.
Thank you. We'll begin public hearing, starting with only application A26-05.
All right, application A26-05 for Jean A. and Christine Mullen. They're seeking a variance from the requirement that a structure may not be used in whole or in part for residential purposes unless the lot in which it is located on has an unobstructed ingress-egress easement to a public street that is at least 18 feet wide to enable the construction of a single-family dwelling. The property is located approximately 477 feet west of Underwood's Corner Road, approximately 1,107 feet south of Bryan Zion Road, north of Kenton. Levy Court District is the 6th. Zoning District is AC. On here, you can see this is the subject property in the back. Here in red is the easement that goes all the way to Undercorner Road. This is the sign posting out from the road. So this is the easement, follows along there. Looking up Underwood's Corner, down the other direction. Looking at the property that the easement is on. This is along the easement as well. Continuing back, property itself, the aerial, and further out. So, sir, if you could please state your name, your address, and allow our attorney to swear you in, and then you can make your statement. You can adjust the mic as needed, and if you need to point at the screen, it'll put a mouse there as well.
My name is Gene Mullen. Live at 48 Oak Drive, Smyrna, Delaware.
Mr. Mullen, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
You may proceed.
You can pull that mic up too if you would like.
This is a fairly easy variance. There's already an easement that was established back in the 20s when these lots were subdivided. Apparently, the easement at the time was 1 rod length, which is 16.5 feet. It's the old surveying measurement. In 1949, Mr. Emerson purchased the property from Malcolm Gerald, and the easement was already there, as far as I can tell from old deeds. So they were all aware of it. This variance doesn't change the width of the easement. I'm just asking for a variance from the 18 feet that's required by the county back to the 16.5 feet. So we're talking 1.5 feet variance. The reason for the variance, and you can see in my application, I built a pole barn back there in 2010 after purchasing the property in 2008. When I got the permit, no mention of an easement was given. It wasn't a problem. I got the building permit, built the building. County approved it, and in February 21st of this year, or of last year, 2025, I had a major fire. It destroyed the building and several pieces of equipment, everything in the building. So I was going to, my application says a modular home, but I've decided to rebuild the pole barn and turn it into a barn dominium. That's very popular today because everything is there, and for cost reasons, it'd be easier to put the building up and basically make it into a house.
Good. Any questions from the board?
Any question?
Mr. Mullen, could you speak to the criteria that relates to the impact that the grant of this easement would have on neighboring properties?
There really isn't any impact. The easement, the deeded easement as written in the deed would remain the same. Like I said, this easement was established a very, very, very long time ago. It's always been in place. My property is basically landlocked without the easement. So the easement has always been there. And without it, without the ability to put something back that I was prior approved for, the property is basically useless. And I already have, in preparation for a house, the county allowed me to put this building up. And I was going to build a house on the property. And you can see in my application, I had several discussions with the then county administrator, Leslie Persons. She approved it for basically an accessory building prior to residence. I needed the building to build the residence. I was going to build it myself in the shop. Anyway, for personal reasons, that didn't happen, and the house wasn't built. So, but wells there, septic's there, electric's there, everything is there for residents.
How are you planning on using it as a residence for yourself?
Yes, this is going to be our house.
Going to be any commercial use of it?
No, I don't have. I'm retired. Been retired for several years, so I have a lot of interest. And it's going to, like I say, it's going to be used for residents.
I have a question for the staff. Is the variance allowing the applicant to build, or is the variance saying this easement, we're going to accept the easement at 16.5 feet forever? In other words, if the neighboring property was going to build now, can we still say to the neighboring property, well, they have to come for a variance to build?
You mean this property here?
The property on the other side of the easement.
The property that the easement is on, so this one here, has a house existing and has frontage. So they don't need the easement. It is just the applicant who needs the easement because his property does not have frontage. So the code specifically requires if a structure is going to be used for residential purposes, like a dwelling, then it requires the easement to be 18 feet wide. So because the easement that was put in place is only 16.5 feet, current code requires 18. That's why he is here. I would have to double check on this property. I can look at the map to see if they have frontage. If they have frontage, technically they wouldn't be required to have an easement, I believe.
Thank you.
Mm-hmm.
Just to add to that, back sometime in the 30s, they changed the configuration of Underwood's Corner Road. And when they changed it, the Zimmerman property, which is the property in the front, became basically landlocked. And his deed doesn't show access to the easement.
So currently there is an easement there already. It's just
Yes.
16.5 feet wide, right?
Right.
So so the only thing that's preventing you from breaking ground is 1.5 feet.
Yes.
So,
And I don't. The 18 feet was established, I think, by the court in 1991, I believe. So it's been around for quite a while. Why I wasn't aware of that, nobody made me aware of it. But anyway, and the easement is specifically deeded to my property.
so regardless of what happens tonight, you're still going to continue to use the lane to get back to your property. You just need 1.5 feet to be able to break ground, essentially.
Yeah, yes, I need the variance to get the building permits to put the building back up.
All right, thank you.
Can you just touch base on the hardship to extend that to 1.5 feet? Obviously, there's a financial impact, I imagine.
I don't really know the reasoning behind why they changed it. 16.5 foot easement had been accepted for probably at least 100 years. And then in 91, they deemed it necessary to change it to 18 feet. And I'm assuming because of fire and ambulance and emergency type. And that's obviously not the case because the night of the fire, I had 7 or 8 fire trucks sitting on the lane. So, and plus there's a standard turnaround in the back. When I built it, when I made the lane, I put a 62-foot basically cul-de-sac turnaround in the lane, which is the requirement for any subdivision. And you can see the loop. You can see the loop as it comes in. The lane continues down to the back of the property, but you can see the loop as it comes around. And I made it specifically at 62 feet, so emergency vehicles could come in, drive right straight back out. I'm rather familiar with construction and building requirements and stuff like that.
So as we are looking at that photo that's up on the screen, you're surrounded by woods,
Yes.
and essentially you truly would be landlocked, and you don't own you only own on one side, so you really expanding would create complications all along the way, right? To make that wider,
Absolutely.
especially with all the woods.
It's completely landlocked. It's bordered to the north by the Holtz Farm. It's bordered on the northwest by the Blackeson Wildlife Area. My property line and theirs are the same. And,
So as far as an exceptional practical difficulty, you are landlocked, and without us granting this, you really would lose your ingress, egress, and be unable to build.
right.
Okay.
And it would, because I do have all the infrastructure to the lot for a residential lot. Like I said, I have a well, I have septic, I have all the electric run to the site. Everything is there, ready to go. And that's been a pretty good expense.
So essentially what you're saying is, and I'm not trying to put words in your mouth, is that it would be a huge financial setback if you have to change things around and start over.
Right.
Okay.
Absolutely.
Thank you.
It would be, like I said, it would render the property almost useless as far as doing anything with it, as far as putting a structure on it, doing any of that. What's there now would just sit there.
Thank
And
you.
it wouldn't, the value of the property would dramatically go down. Which would, a little side note, would affect my property taxes greatly, probably.
I have a question for Jesse real quick, or for staff, and then another comment, I think. Is it because the property is in excess of 10 acres that he can have an ancillary structure on it without a
dwelling? So the structure that was there was issued an agricultural permit at the time. I believe it mentioned that there were goats or something along those lines. It was stated on that permit that there was intent to build a house, and when the house was constructed, that structure was then converted to a residential structure. That never occurred, and that's kind of at the point where we are now. So nothing is permitted to be there at the current time. Since the structure that was there was burnt down, I believe we may allow a temporary structure for that in the interim, but otherwise, no.
But other agricultural structure could go on this property without an 18-foot easement.
If it was a bona fide farm. So if it was being used for farm purposes and we had the documentation to show that, then yes, we could issue an agricultural permit.
So Mr. Mullen has, just to kind of recharacterize what's been said, Mr. Mullen has access to this property. over the 16.5-foot easement. He doesn't need to take any additional land from anybody else or reconfigure anything. The problem that he is confronted with is a zoning code provision that requires for any residential structure that is served by an easement, that the easement be at least 18 feet wide, which he doesn't have and can't get. So
When I first viewed this application, my thoughts immediately went to, well, why isn't it grandfathered in? Because it's been there and it's been ongoing. But then, you know, you realize that when everything goes down to the ground, you're in the start over situation. So, but that my first thought was like, why isn't this grandfathered? So, thank you.
And that was my question. It was, the permit for the original building was an ag permit for an ag structure. My understanding with Ms. Persons at the time that I was going to construct it to a residential accessory building code. And then when the house was built, it would be changed over to an accessory building. And that was the reason that the building was built in the first place.
if there was a house there before the ordinance was adopted to require 18 feet of width on an easement, then he would have been grandfathered. But there wasn't a house there at that time, so that's why he has to comply with the code or get a variance. Mr. Mullen, has anyone expressed any opposition to you, and can you characterize that? Do you want to speak to it at all? Because once you sit down, that's your last chance.
Well, my neighbor, obviously, but I do have my other neighbor that owns the front piece.
Well, you say obviously. I don't know that we know what you mean by obviously.
Well, I won't. I'll let him explain. I don't know. I honestly don't know. So anyway, I'm assuming opposition, and that's where we're at. Initially, planning staff thought it would be grandfathered and wouldn't be an issue. They hadn't mentioned the 18-foot requirement, but subsequently, I guess they did a little more research and came up with I had to have a variance, which I didn't think it was a very big deal for 1.5 feet, but.
Good. Any other questions? All right. Thank you, Mr. Mullen.
Is there anyone else present that would like to speak in favor of the application? Please state your name and your address and allow our attorney to swear you in.
My name is Fred Zimmerman. My address is 238 Tyler Drive, Dover, Delaware. And
Mr. Zimmerman,
yes,
over here. Do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I affirm to the truth.
You may proceed with your remarks.
Okay. As I stated, my name is Fred Zimmerman. If you look on your on the screen, my property is the one toward Underwood's Corner Road. It's 8.5 acres. So I'm in front there with where your arrow is. That is the plot that I own. I owned this property before Mr. Mullen owned his. And my land also borders that easement that Mr. Mullen has going back. On my property, it does not show the easement. At one time, the road had been changed, and I don't think they required any easement because we were right by the road, but the road was made in a more gradual curve. But I guess that's not the subject of the evening, but my property follows his property along the easement all the way out to the road. As was stated before, he has 16.5 feet wide easement, and I'm recommending to the Board of Adjustment that they give due consideration to Mr. Mullins' request regarding the more recent requirement of the additional 1.5 foot residential use. I thank you for your listening to me. Is there any questions before I sit down?
I have one question. So your property, do you access that easement as well? Obviously, I don't think there's any structures on your property. It doesn't look like it, but.
There are no structures on my property. As you can see, it's all wooded, as most of Mr. Mullins is. I was going to put a house on it a few years ago, but I was informed that I needed an easement or access to that property that I did not have, and I was not able to do that. I have not been restricted to get onto my property from the road. It's only a small stone's throw from the road into my property, as you can see, but I have not been able to put a building on the property.
Any other questions from the board? We're all good. Thank you, Mr. Zimmerman.
Okay, thank you.
Is there anyone else present that would like to speak in favor of the application? Do we have anyone online?
If there's anyone joining us online that would like to speak in favor of application A2605, please indicate by raising an electronic hand or pressing *3 if you're joining us by phone. No hands raised online at this time.
Thank you. Is there anyone present that would like to speak in opposition of the application? Sir, you can come up to the podium. Please state your name and your address and allow our attorney to swear you in.
Ronald Emerson. My address is 3821 Underwoods Corner Road, and I own the 3845 that has
Mr.
the
Emerson?
easement on it.
Mr. Emerson,
Yes,
do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Could repeat what you said just now and get started.
Yes, I own the property at 3845 Underwoods Corner Road.
Can you point to that on the screen next to you? It'll show us.
Yes. It's right, the one right on the curve that has the easement to it. And I also own the lot that's in the back, 3785, that has a mobile home on it. And these are all 2-acre lots. And my biggest concern, I haven't ever been able to address it or do anything about it, is the traffic. And I have spoken about it, and I don't get no results. That's really all I asked for, cut down on the traffic. They go too fast, and there's too much. You know, before the fire, he was building cabinets and stuff. He was basically running a business. And I didn't care, you know, and I told him that I don't care of anything that you do on your property if it doesn't hurt me. But that hurt me. It hurts me and my family because we don't feel safe. You know, my wife's got a dog. My granddaughter has a dog. We like to go out and walk the dogs. And we don't know the people that's coming in on our property. And it's gotten so bad, I had to start stopping them to get them to not speed. And Gene Mullins his speed's okay, but it's the other people. You know, it's all the guests. I don't know none of them. And back in the back, at the back lot, my son lives there, and he's concerned about the gunfire because he was having too much shooting. You know, at one time he had the town of Smyrna out there, the police department, you know, getting their recertification. And then there was a gun club was coming out. And man, you talk about traffic, and we don't have that much space. I mean, at the narrowest point, I don't have a pointer, but right up when you come off the road, and the pictures that
You could point to the screen.
Well, where this home is on 3845, well, where it's like a dog leg, well, that's the closest point. And add another 1.5 feet of that, you're not far from the house. It's 25 foot from the corner of the house to the property line at the closest point. And now you take 18 feet away. We want to put a deck there, but you know, when you get...
Mr. Emerson, they're not taking any of your land.
Yeah, but it can't be obstructed.
No, that's not so. There's no expansion of the easement that we cannot grant an expansion of the easement. This board can only authorize that a residential use be placed on that property despite the fact that it's served by an easement that's less than 18 feet. But the dimensions of the easement will not change. If we grant this variance, the dimensions of the easement will remain the same. They'll be 16.5 feet.
But I'll have to recognize that other 1.5 feet.
You do not.
I mean, I can't put nothing there, no fence.
No,
you
don't. You're not. There's no additional 1.5 feet that you have to acknowledge. We were just simply saying that he doesn't have to have an 18-foot easement. He can have a 16.5-foot easement,
right.
And that would be sufficient. This board can't take any of your property from you.
That was one of my concerns, and the other concern is the safety, because once a house gets there, then it's going to go to a workshop again, and it's just going to be all over. And it's been almost 18 years, and every year it got worse and worse as far as the traffic and the shooting. And my concern was the back trailer, because it's right there.
That's a separate issue.
Yeah.
So I mean, obviously, he could build the resident. If we grant this approval, we could build the residential house.
Right.
But yeah, if he starts doing like a home-based contracting, that's a
Right.
whole nother issue that he will have to come into the county for. But for tonight, we're just granting just hearing the 16.5 easement.
Well, my concern is just us being safe. But I can't do nothing about it. I've stopped them. I've told them.
Have you thought about installing speed humps?
I have thought about it, but it just, I don't know. It just seems like another job I got to do. I went and put speed limit signs up, because I figure if I put up 5, maybe I can get them to do 10. But I have thought about speed bumps, but I have to use it too. And I'm going to punish myself, but if it continues, I won't have a choice. I'll just have to do it that way.
Do you have a sense of how many cars are on that?
It varies.
I know, but
Yeah.
give us some idea of what you mean when you say there's a lot of traffic.
It can be anywhere from 5 cars, and I've had up to 24. I've counted them.
In a what? In a day or?
Yeah, and that's in. And then, of course, then they come out. And
Every day?
not every day, no. It's sporadic. Some days would be 5 cars, some days 7 cars. But the most was 24, and that was when there was a gun club back there.
Well, when you say there was a gun club, there was
Yes.
shooting back there,
Yeah.
but was there, what do you know about there being an actual club that people were members
Well,
of?
the people that came there, because somebody damaged my pole building. And I went to him about that. And I didn't want anything. I fixed it myself, but all I asked was him to cut the traffic down. And he told me it was his property, not mine. It's his. So, and that's when I didn't want to talk to him no more after that. That was it. So that's why I'm not supporting this. And that's not my character, because I like people to do what they want with their property. But this affects me too much.
How long have you lived here?
I've been on part of that property all my whole life, 73 years,
And has that easement been there the entire time?
since 1943. I have the original deed when Malcolm Gerald sold it to my father. And it has in there about the perch, the 16 and a half feet, and then it would go on to the next owner. You know, that's how it reads. I have it. Yeah.
So as long as you've been there, that easement has been there.
The easement's been there, but it was never used until Gene bought it. Because when Malcolm Gerald owned it and his wife, they went through the woods. They went on Mr. Zimmerman's property. And that's still there too. But that's how, they never used that easement ever. He would go back there and use that property that Gene has now, and they just put their agricultural stuff they weren't using no more. They put it back. Old Bob was basically a dump. That's what it was. But they accessed the woods on Mr. Zimmerman. They never used the easement. So it was never used.
Thank you.
You're welcome.
You said your son owns the property behind you?
Pardon me?
Your son owns the property behind you?
He doesn't own it. I own it. I mean, he may own it someday.
Do they access that easement? Is this the easement?
No,
Get that? Okay.
no, we have a 25-foot entrance for that.
Okay. So this easement is only to access that site?
Exactly, just for that, not for anything else.
Okay.
And back in the back, when you're looking, well, you can't see it in that picture, but I have a pole building down there on the left. And that was what was damaged. Yeah, it's just,
Was it damaged
I'm
by a
very
car?
concerned. Pardon me?
Was it damaged by a vehicle?
Well, it was some type. I didn't see it happen, but we don't have anybody go there. There's only us, and then all the folks he has over. It got really good after the fire. It did, and I'm just afraid now once he gets established again, it's gonna start all over, and I won't have no recourse. I've lived with this ever since he's bought that property.
Any other questions from the board? Seeing none. Thank you.
Okay, thanks.
Is there anyone else present that would like to speak in opposition? Is there anyone online?
For our guests joining us online, if you would like to speak in opposition to application A2605, please indicate by raising your electronic hand or pressing *3 if you're joining us by phone. Still no hands raised online.
Thank you. Seeing no one else, we will close the public hearing for application A26-05.
Thank you. So that closes the public hearing. And when you need a break, just keep rolling. Keep rolling, right? Yep. All right. You want to do roll call?
Yes, sir. Mr. Simpson? Here.
Here.
Mr. Gallo?
Here.
Ms. Denny?
Here.
Mr. Carter?
Here.
Mr. Jenkins?
Here.
Ms. Hudson?
Here.
Mr. Cusick?
Here.
That's 7 present.
Thank you. All right, business meeting. We need approval from business meeting minutes from the February 19th meeting.
I make a motion that we approve the business meetings from February 19th.
Second.
Got a motion and a second for the approval of the business meeting minutes. Notice of decisions, we need approval for A26-03 and A26-04.
I'll make a motion that we approve.
Sorry, did you want to have the the
yeah,
vote
vote on
on
that.
Sorry.
the minutes?
All in favor for the approval of the minutes?
Aye.
Aye.
Thank you.
Sorry, now notice of decision. A26-03 and A26-04.
I'll make a motion to approve A2603, A2604, notice of,
Second.
Motion and a second, all in favor? Aye.
aye.
No old business, and we'll get into new business.
Only application is A26-05 for Mullen, seeking a variance from the requirement that a structure may not be used in whole or in part for residential purposes unless the lot in which it is located has an unobstructed egress easement to a public street that is at least 18 feet wide to enable the construction of a single-family dwelling.
Any discussion or motion?
I just want to have it crystal clear, Jesse, right? This is for the residential property. We are not making any easement bigger or anything like that, correct?
Correct. It would just enable the applicant to utilize the existing 16.5-foot easement to build a home on the property.
And to also be clear, the housing that's there already is using the 16.5-foot easement presently.
The housing that is there is not approved housing.
The adjoining properties.
Oh, I'm sorry. Yes, on the. I'm sorry. Can you state your question again? I misunderstood.
The homes that are adjoining on the other side of the easement have houses on them, correct?
Correct. They do. They also have frontage. They do not need an easement because they have frontage along the roadway.
Okay, thank you.
Mm-hmm.
Yeah, this is the only property that has that accesses that easement. And the safety concern about the opposition, I mean, it's a valid point, but if he does sell in cabinets and stuff like that, it's a whole different scenario with home-based contracting that he'll have to.
And he doesn't have the road frontage to do a home-based contractor permit there.
So that would be an issue that he can speak to the county about. That's not on within our
No.
Yep.
venue jurisdiction.
So we're voting tonight just on the easement and a residential property.
Okay. This is a tough one, but essentially, this was the width of the road from the beginning, when all this was plotted, and there's really isn't any room to widen it, and whether there's a business and whatever was discussed by the witness for the opposition to this evening, whatever that is not for us to make a decision on. And in order for him to have the appropriate ingress and egress, he needs the variance on this property. He needs that extra little bit of width. And so, and it would be a hardship for him, in testimony this evening, it would be a hardship for him. This is all very heavily wooded area there, and the cost of like, and just even to sell the property, whatever, he's going to need this easement. So I think there has been demonstrated an exceptional practical difficulty because of the width of that ingress available to that property.
Yeah. I was going to say, in addition to that, I mean, there was discussion about it being landlocked. I mean, that creates an exceptional practical difficulty, but just that alone, let alone the history. There's extensive history here from the time that Mr. Emerson bought, and then the time that Mr. Mullen bought, and then what's happened, you know, not for us to solve, but our issue is the access easement.
I agree. So my motion is that I make a motion that this variance be approved for the reasons I stated, that, you know, there is an exceptional practical difficulty. He would be landlocked. That's enough, I guess.
I'll second.
Got a motion and a second?
Thank you. Mr. Jenkins?
Yes, I vote in support of the motion for application A2605 based on the testimony we've received tonight and the extensive information given to us by the staff, and the easement. By granting it, it's very minimal. You're talking 1.5 feet.
Well, thank you. Mr. Carter?
I'll vote in favor of the motion based on the testimony tonight and the staff recommendation.
Thank you. Mr. Simpson?
I vote in favor based on the testimony tonight and the staff recommendation and the exceptional practical difficulty that it would put on the landowner to do anything with his property.
Thank you. Mr. Gallo?
Vote in favor of the motion. The applicant is attempting to make a normal improvement on a property, and the location of that property presents an exceptional practical difficulty, and the relief he is asking for is minimal.
Thank you. Ms. Denny?
I vote yes. I do see an exceptional practical difficulty, and I believe that he would be landlocked if we did not grant this variance.
Thank you. Ms. Hudson?
2605, I vote to approve based off the staff recommendation and the public testimony that we heard tonight. I believe allowing the applicant to utilize the existing 6.5 access easement to construct a single-family home is in with character of the surrounding area, and I believe there is an exceptional practical difficulty with the homeowner being landlocked.
Thank you. Mr. Cusick?
I vote in favor of the motion, just per staff recommendation, and the hardship is clearly there. The financial impact to make this applicant expand the existing egress is a pretty financial impact.
Thank you. That is 7 in favor.
Thank you. With 7 in favor, application A26-05 is approved. A motion to adjourn.
Okay.
We can't have any.
Give us 2 seconds. Make a motion to adjourn.
Second.
Alrighty.
Aye.
Aye.
In favor?
Aye.
Aye.
I just wanted to let you know, there was never a business there.